And before he completes his second sentence, they threw away the papers. Sorry, Mr. So-and-so, nothing in this. So he was terribly disheartened. I was standing outside the court for waiting for my own matter. So he asked me, અહીંયા તમને વર્ક સેટિસ્ફેક્શન શું છે? હું આટલી બધી તૈયારી કરીને આવ્યો છું. I have several points to raise. Before I open my mouth, this Johnny throw away the papers and say, sorry. What sorry? I said, Joe bhai, this court is not for work satisfaction. This court is for teaching you detachment. તો બહુ મમત ના રાખશો. You need confidence first of all, and confidence comes from courage. It's like jumping into the sea. You have a well-established practice in High Court or in some other High Court. You have to give it up. Many people will tell you, મૂર્ખામી ના કરશો તો ક્યાં જાય છે? So if you have courage, if you have confidence, knowledge comes by itself. Don't worry about it. Thank you.
I'm first so thankful to Bar that such a organized just a great seminar that we as a juniors who have just 5 years or 7 years of practice, I have personally learned many things. That two questions that I have. First question is, if a woman who has been deserted by her husband within 2 or 3 months of her marriage, and if she filed a 125 application at the trial court, but his husband has intentionally evaded the proceedings and does not want to come in limelight. If a summons has been issued, everything has been done. Even the father and mother of the boy has declared in the newspaper that there has been no relationship between of us and with our son. So I just have read in the newspaper of Times of India, Justice J.B. Padiwala's recent judgment that after the death of the husband, that the father-in-law is liable to pay maintenance to the woman. But another law is that after 7 years, no person come into the limelight, renounce the world, he is declared as a dead person. But for a woman being a lady who has been deserted and the husband is intentionally evade the proceeding, is it possible for the High Court to interfere and issue any writ for to grant the maintenance if any other way till the waiting of the 7 years of law?
I don't think so, because see, Article 226 is very wide. It empowers High Court to issue appropriate direction order for enforcement of fundamental right and for any other purpose also. But any other purpose you will have to read in a particular way only. I would respectfully submit that it would only exclude contractual rights, hereditary rights, or rights of like maintenance which are flowing from statute. Those rights will have to be decided by the competent court. You cannot directly jump those courts and directly come to the High Court, even though you may be in a miserable position. But High Court will not be able to offer any aid to you in such a circumstance. You will have to come through proper channel only.
So after, if the proceeding is going on at the trial court, in between
High Court will not have direct jurisdiction. It doesn't have any original jurisdiction of such a nature whereby it can directly issue maintenance orders.
And another question is, if writ can be issued to consumer forum if consumer forum has exercised any ultra virus action?
Yes. Actually, all authorities, all tribunals, now courts are excluded because of this judgment. Otherwise, courts are also amenable to writ jurisdiction. Writ of certiorari can go to the court also. Even this recent judgment has not looked at the history and one recent judgment of the Supreme England judgment, where even writs have been sent to the courts also. So even consumer courts are amenable to writ jurisdiction. So writs can go to the consumer courts also. There is no difficulty. If consumer court has exceeded in its jurisdiction, it has exercised the jurisdiction not vested in it, or its order is suffering from a particular error apparent on the face of the record, it can be subject to the High Court's jurisdiction. But since there are appellate remedies, Consumer Forum, you can
Yes,
file an
good,
appeal to State
good.
Commission, National Commission. So when alternative remedies are there, usually court would direct you to exhaust those remedies first. Otherwise, it is not barred. Jurisdiction is not barred.
I may add one thing regarding this consumer thing. As far as National Consumer Forum is concerned, you have an appeal to Supreme Court,
Yes.
direct appeal, there's statutory appeal.
One question is, all statutory authorities of government are found guilty of performance. Assuming that section 254 is giving license for construction, approval, but they never acting as per their statutory powers. And what happened? 10 lakhs constructions buildings has been carried out in Ahmedabad. And Justice K.M. Mehta has also reported. Now what happened, my lord? High Court is utilized as a weapon or catalyst. So once High Court directs, then they move. They come and close. How it can be done? And why?
Actually, writ in the nature of mandamus is meant for such an inaction. Suppose the authority is not functioning, then you have to approach the court first. You will have to make a request to the authority that you act. If they fail to act, then court would direct a writ in the nature of mandamus or any other appropriate direction, directing the authority to act in accordance with law. If it grants discretionary power, the discretion will have to be exercised in accordance with law. High Court cannot direct that authority must exercise a discretion in a particular manner only. So, recent judgment of Honorable Supreme Court on 2007 Moni Surat case, in that case, High Court directed Municipal Commissioner to demolish a particular offending construction. And the Supreme Court said no. High Court cannot even take away discretion of Commissioner because all illegalities are not liable to be demolished. So it can be cured also. In certain cases, by charging impact fix, certain illegalities can be regularized. So even High Court cannot direct Commissioner by mandamus to take a particular decision. So they are discretionary power. Thank you.
Many orders of the courts are not compliant.
We will have a second session now. I think people are hungry. એ બધું કન્ટેમ મંટેમમાં આવશે એ પછી આપણું એનું કરશું બીજું એ કન્ટેમનું કરશું.
Contempt no. Thank you very much, members of the bar. The time is running fast. અચ્છા તમારે કંઈક પૂછવું છે? Just a minute. Okay, fine. Yes, gentlemen.
Sir, very kind of you for giving me the opportunity to raise a question on the compassion matter under Article 51 AG, read with Article 21. The Supreme Court has recently a very nice judgment delivered by the Honorable Justice Radheshyamji that all living species are part of environment, and if all these species are not entitled to fundamental right for their existence, then disturbance in environment would cause tremendous losses to the whole world, not only to India. And they have changed the definition of the word life. The word life now has been expanded to cover not only human beings, but also all the living species. And therefore, any disturbance in the environment would cause a tremendous loss to this nature. How this government can continue the meat export policy, which is causing the national loss to the extent of 4 crores of our animals' wealth, which is highly precious to our country because of the fact of this killing. Sir, 50 crores of our people have become a below poverty line population, as a result of which the inflation has been thrusted upon us, and our people are facing the great cost of living in their difficulties of life. So how this remedy can be made available by the Supreme Court? Even then, the UTO government has not reviewed their this meat export policy by not allowing them and that not reviewing by Congress
a
government.
question-
Even BJP government is not reviewing.
The question is,
Therefore, I have to ask a question, whether it is feasible, practicable to file a writ petition before the Supreme Court through our honorable judges, through our honorable bar, honorable advocates of this bar.
the question is of general importance, and it will have to be taken to its logical end in future. You are saying that creatures are also entitled to right to life. That is understandable. But for that cause, somebody has to espouse the cause and has to make out a case for approaching the Honorable Supreme Court. At present, we cannot give specific answer to your query. Otherwise, all human beings and all animals have a right to life, and that cannot be taken away without due process of law. That is what you want to contend. So I think that's it will have to be taken to its logical end in future. Thank you.
About the eradication of
Yes,
the
yes, yes.
export policy, which is draconian, dangerous, destructive, and anti-national.
Yes,
That is
sir.
what- Please give me.
We appreciate it.
What is?
We really appreciated it. Well, last query, sir. We appreciate it. Thank you. Yes, sir.
Sir, in a petition under Article 226, I pray for several things. Hello. In a petition under Article 226, I would have prayed for several things. Yes. I would have prayed for either a writ, in a particular writ, or order or direction. Yes. Subsequently, in the order, is the court required to say that I am issuing a writ? Otherwise, the order would read that the respondents are hereby directed to take this person into job. Yes. So, would that be a writ? Would that be an order? Would that be a direction? And what would be the implications of all of these? Because my right to file appeal, would I be able to, if there is merely a direction issued, would I be able to file an appeal?
Actually, these three words have been used: directions, orders, or writs under Article 226. So it would be open to the court to issue any of that thing. Either it can issue direction, it can issue order, or it can issue writ. Does not necessarily mean traditional writs. As I said, it said that including in the nature of writs of mandamus, etc. So it is not necessary for the High Court to issue a particular writ, because we have not borrowed, as I have repeatedly said, we have not borrowed the traditional writs in their original form. We have borrowed a modified procedure, and we have conferred a very wide jurisdiction on High Court. So it is not necessary for a High Court to issue a particular writ.
In fact, from an order, how do I find out if it's merely a direction or a writ?
Merely,
Because-
you will have to see the operative portion, how it is couched. The language will have to be seen. And the appeal, as I said, that Article 226 is original jurisdiction, so LPA would be maintainable. It is just to curtail litigation. Judges have evolved that certiorari you are invoking supervisory jurisdiction, and therefore LPA is not maintainable. In their zeal to curtail the litigation, these kind of novel ideas are floated, and sometimes they are accepted also. But ultimately, you have to go by the bare text of the Article 226 and the historical background. Thank you.
Thank you, sir.
I may now invite Sudhanshu Patel to deliver a vote of thanks. Please, Sudhanshu Patel, the secretary of our association.
Thank you, friends. I will not be a hurdle for your lunch. I am really thankful to Mr. Asim Pandya, our Vice President. I am thankful to the other speakers, Mr. Anand, who is a senior advocate and a member of our bar, Mr. Kavina, our senior advocate. I will be again thankful to all my office bearers and the committee members who was arranging, and really thankful to this August gathering who had been a part of the function today and had made this function a grand success. We will now join. I will request all of you to join for a lunch. Thank you.